This is a data privacy detective. Well, it's April, it's springtime, and we're going to do our monthly report on 3 important developments for the month of March 2024. And with me, as always, are my 2 good friends, Brian St. Amour and Yugo Nagashima. Brian and Yugo, happy spring. Brian, good to have you on the show again.
Thanks for having me again, Joe, even on this April Fool's Day.
April Fool's. Well, we're going to tell the truth today, right? But Yugo, how about you? You have a foolish joke for us or anything, or shall we get started?
Yeah. The April Fool's joke is we now have a U.S. federal privacy law.
Oh, that is a joke. But we will have a bit of a small one you can report on shortly.
That's
but we're
right.
going to start with the state of Illinois. And Yugo and Brian, you're both members of Frost Brown Todd LLP, a coast-to-coast law firm. And you both have deep experience with technology generally and, of course, data privacy in particular. So thanks for being commentators today. Well, let's get into BIPA. Oh, BIPA, it sounds like a baby burping, but it's not. It's the Illinois Biometric Information Privacy Act. It's been around for a while. And Brian, you've talked about this before, so help our listeners understand why we're talking about BIPA today.
Yeah, I think, just start and kind of just explain what BIPA is.
Sure.
It was originally passed to protect an individual's biometrics data, things like fingerprints, facial geometry, images, DNA, all those other kind of indicators of biometrics of a specific individual. And what was interesting with BIPA, versus other laws that have tried to this was originally when it passed in 2008, it allowed for private lawsuits over violations, and really has become in the last couple of years, which is why we've talked about it so much in this last year, the basis for more and more class action lawsuits.
Yeah, we've seen a lot of private lawyers get into the business, and of course they're interested in doing that from a class action standpoint. So it stands to reason. But before we get into the details of proposed changes to BIPA, help walk us through why the Illinois General Assembly's talking about BIPA.
Yeah, and so there's a couple kind of key areas, and the first is kind of focuses on the requirements for companies to obtain written consent before collecting and storing the information, and the law requires companies to have policies around that use in addition to the consent, and those policies need to cover the use, the retention, destruction, and the proposed amendments really are starting after there was a very notable case that we talked about on this show, which was dealing with BNSF Railways, and it was their settlement after the Illinois case of Cochran versus White Castle.
That was what, $75 million? I mean, that was a big announcement. Yeah,
it was, and that was the settlement, and so BNSF was potentially on the hook for well over $100 million under the statute, so allowing it to move forward. The settlement was really driven off that Illinois Supreme Court case, which really determined how dramatically the way the damages were increased. So the Illinois Supreme Court really said plaintiffs could bring separate claims for each time their data was collected. And so that's really one of the primary kind of factors, were the amounts of these potential exposures, as well as how they were calculating, and the requirements really is what seems to be driving the Illinois General Assembly to taking action to address this after the Illinois Supreme Court kind of had a series of cases where they kept broadening what seemed like broadening the law.
Yeah, well, how's the legislature looking at this?
So the proposed bill is going to seek to revise BIPA in a couple key ways. The first is they're going to address the accruals of violations. So as I mentioned, rather than allowing every instance of data collection to be a new cause of action, they're saying no, there'll be a single accrual violation. And that's going to be a pretty significant change in terms of how that change would affect.
Well, that would be a significant change. With lower costs, I suppose, to the industry. Give us an example of how that might affect business.
Yeah, so look at an example of it where an employee uses biometric data for, say, a fingerprint to clock in and clock out. And so under the current BIPA, each individual scan during the workday could constitute a separate violation, which could lead to a lot of statutory damages, which, as a lot, everyone knows, that could be $1,000 for a kind of standard violation or $5,000 for a willful violation. So those violations, really, those amounts add up a lot for each individual employee. Under the proposed bill, only the initial collection of the biometric identifier would be considered a violation. So if they didn't have the right consents, didn't have the right policies, you're looking at a single violation per employee versus the subsequent scanning, clocking in and out wouldn't give additional violations, which would kind of potentially lower the overall liability on a per employee basis as opposed to a per employee per application.
Yeah, otherwise it's sort of thing. Each time the employer, clocks in, then it's a new violation, and that seems a little bit of overreach. Where the whole idea is that you should tell them this is what you're doing, and once you've told them, they should remember that, I suppose. Well, give us another touch on at least another part of the bill about the definition of written release. What does that mean?
So there's a little bit of ambiguity in the current law about whether or not electronic signature, or as you think about those, whether that's in like a DocuSign perspective or some other type of click wrap agreement, what the legislature seems to want to do is, while we're closing the loops of these other potential account or accrual violations, let's go ahead and make sure we understand where the status of and flexibility of digital e-consents are coming into play. And really what this would do is it would formalize that a electronic signature would be included under the written release language. And this adjustment really is focused on the evolving nature of technology and, would really allow to facilitate compliance with the law by allowing electronic forms of consent. And this would streamline the process of our businesses while still protecting the individual's biometric privacy rights. And it really, if you think about back in 2008, a lot of these e-consent type software, were not really out in the mainstream.
Well, when it gets enacted and signed into law, let's talk about it again and inform the listeners. But it's sort of an example that sometimes the initial law goes overboard or underboard, whichever it may be, and then the law tries to catch up with what happens. Thanks, Brian, for giving us more insights into how Illinois is responding. It was a pioneer, after all, in the biometric privacy landscape of the United States.
Yeah, it is, and it still remains the only state that allows a private right of action here.
Yeah, most leave it up to the Attorney General or an agency. Well, let me turn next to, let's go south. But before we do that, let's go worldwide. Hugo, you're with us. And we're going to talk about what President Biden has done recently and then what Congress has done on a bipartisan basis. And this has to do with what happens with American data that is shared or sold to foreign adversaries.
That's right.
And it looks like March has been a busy month in that world. So what's been happening?
Yes. So it begins a little bit before March, but right around the time of March, President Biden issued an executive order which prevented access to Americans' bulk of sensitive personal data and U.S. government-related data to countries of concern.
Countries, well, we're concerned about every country, right? Now tell us more about, well, why has this executive order been issued?
Before the issuance of this executive order, we really haven't seen in the U.S. much control over sensitive personal data that's being used by foreign countries, right? Well, we have laws in states within the United States of how sensitive data should be governed. But what this executive order addresses, and later the congressional bill that's out there addresses, is they're concerned about foreign adversary countries relying on AI to manipulate the bulk sensitive personal data, because now they can deal with big data. They can crunch the numbers, and through crunching the numbers of not just the sensitive personal data, but U.S. government-related data, they can engage in a wide range of malicious activities such as espionage, influence, kinetics, cyber operations, or identifying potential strategic advantages over the United States. So this executive order is trying to control that.
Well, what does it do?
Okay, so with the executive order, it's still very vague, and As we talk a little bit more into the congressional bill, it's a little more detailed, but let's go for the executive order first. So it orders the Attorney General in coordination with the Secretary of Homeland Security, in consultation of heads of other agencies, to issue regulations that prohibit or otherwise restrict U.S. persons from engaging in transactions of property which involves bulk sensitive personal data or U.S. government data. And one of the things that specifically is requested is identifying the classes of transactions. So what kind of transactions would involve bulk sensitive personal data or U.S. government related data, and establish a process to allow for licenses. So there's this open border for data concept where as long as you can obtain a license for the U.S. government, of course you can obtain information. So having a procedure that allows, foreign countries to obtain a license, authorizing such transactions to happen or to transfer the bulk sensitive data.
Right. And although we're reading the headlines about Congress is dysfunctional and so on, but it works and things go on and things get agreed. And certainly adversary countries are something there's bipartisan concern about. So Congress, what's Congress been up to?
So Joe, you're completely right. Many people following from foreign countries and even within the United States have seen some of the partisanship in Congress, but this is one of those issues where regardless of Republican or Democrat, parties agree. And there was a bill passed called the Protecting American Data from Foreign Adversaries Act of 2024, passed on March 21st in the House of Representatives. And this was unanimously passed. And this would restrict the sale of American data to foreign adversaries by a data broker.
So in fact, by data brokers. Okay. And just briefly, what are data brokers?
So
under the Act,
it's defined as an entity that for a valuable consideration, and valuable consideration can be more than just sales of money, right? Sells licenses, rents, trades, transfer, releases, discloses, provides access to, or otherwise makes available. So essentially makes available U.S. individuals' sensitive personal information to individuals to another entity that is not acting as a service provider. So the key aspect here is someone who basically is not a service provider, who has data about a person and then basically sells it or provides it for some kind of trade to another entity.
Yeah, okay. And how are countries of concern, meaning adversarial type countries, how are they defined, if they are, by the House?
They are. So minor list, but some of the countries that are listed is North Korea, China, Russia, and Iran. And the law is a little bit different from the executive order. It also pulls into entities controlled by such countries.
Okay. And the sensitive data, how's that defined?
Sensitive data is... And it's the typical of what we see in U.S. privacy, state privacy laws. It's government-issued identifiers such as social security numbers or driver's licenses, passport numbers, financial accounts, biometric information, genetic information, precise geolocation information, and private communications of sensitive emails that are not just made out in public.
Right. So your home address may not be sensitive, but the rest of it, a lot of things will be. And we'll see how it unfolds, and then the Senate has not adopted it yet.
Not yet, but that will be something to keep an eye on.
Probably will, with unanimous approval in the House. Okay, well, now let's go south to Florida. Now, in a prior discussion, I reported on the Privacy Act involving, it's really not a Privacy Act. It's really how do minors use social media today? Minors, MINOR. And there's a lot of concern across the spectrum that for some younger people, they just use it too much and they get addicted to it and problems occur and, all sorts of problems. There have been reports of suicides among teenage youth and so on. And whatever you think of that overall, this is certainly an issue that we've seen states get into. And the Florida legislature, on a very bipartisan basis, had passed something, and Florida's governor had vetoed it in early March of 2024. And yet 3 weeks later, we have a new act the governor signed on March 25. Very quickly worked out. And so what is it? We're just going to talk about the highlights of this, but this is a brand new thing. The law, we'll call it House Bill 3, that's what it's known as. It will become part of Florida statutes effective January of 2025. So we've got about a 9-month phase-in period before it's effective. Now, the headlines say this will ban social media use by minors under 14 years of age. And it won't allow 14 and 15-year-olds to get social media accounts without parent or guardian consent. But let's take a closer look at it. First of all, it does not actually ban social media use by children at all. What it does is to make illegal for a social media platform, as defined, to enter into a contract with someone under 14 years old to become an account holder. So let's take a pause here. So if a parent or guardian wants to have his or her own account and let a child under 14 use it, that can go right ahead. Well, let's get into definitions then. What's a social media platform that's actually governed by this act? Well, it's not every social media platform. There's a specific meaning that limits its reach under this act to being an online forum, website, or app that satisfies each of 5 criteria. First, the social media platform, the SMP we'll call it, lets users upload content or view content of other users. Well, that covers almost all of them, maybe all of them. But then 10% or more of active users under 16 years of age have to spend an average of 2 hours per day or more on the online forum, website, or app. And that's either per year or per prior month for newer SMPs. And then the SMP has to use algorithms that select content for users based on user data that's gathered. And then the SMP has to have one of 5 what are called addictive features: infinite scrolling, push notifications or alerts, display of personal interactive metrics that indicate a reaction to have shared or reposted content, and live streaming, or a function that lets users or advertisers broadcast live video content in real time. So only an SMP that fits these 5 criteria is covered by the Act. And the Act makes very clear that this will not apply to entities that simply facilitate email or facilitate sharing of photos or videos or other things, only between a sender and named recipients without posting or making public beyond the named recipients. Well, it'd be interesting what that means in practice. What if somebody says, I am posting to any friend who wants to join me on Facebook? Is that under the Act or not? One must wonder. And then children between 14 and 15 can get an account with SMPs that are covered by the Act as long as a parent or a guardian consents. Well, it'll be interesting if one parent says, yeah, go ahead, and the other says no. What happens then? Well, the Act doesn't tell you. It may be that the statute means the child gets to open the account when either parent or a guardian says okay. And then once that's created, you're done. It's kind of once you're done, that's it. One and out. Well, it's a curious way of dealing something that was founded on a legislature finding that social media can be addictive and dangerous to youth. But there we are. The Act requires SMPs governed by the Act to terminate contracts with anybody under 14 years of age. And then with anybody 14 to 15 whose parents or guardians request that it be terminated, or if they request it themselves. Now, it's important. It's an important feature here to say that the SMP must do this for accounts belonging to an account holder who is, quote, likely younger, close quote, than 14 for purposes of targeted content or advertising. Well, how's that going to work? Likely younger? So the SMP has to decide whether it's likely that somebody coming on board and sending them a message or is applying is likely younger, meaning, I guess, more likely than not. It doesn't say whether it's beyond a reasonable doubt or 51% or what. Well, that'll be interesting. And then the account holder can dispute the termination. So let's say somebody, a minor, can younger than 14, can come in and terminate the parents doing this, and they have 90 days to complain about it and get that resolved. Well, this is going to be a new form of family dispute resolution, I suppose. The SMP must terminate the account if a child under 14 requests it. One would wonder why one would if one signed up for one. Or if the confirmed parent or guardian of the account holder requests it within 10 days. Well, again, we're back to what if one parent says, okay, and the other says, well, I said it was all right, and the child says, well, I want it. And, oh, we shall see. And then the legislature says that the parent or guardian will have to prove that they're a confirmed parent or guardian. You can't just claim it, you have to prove it. And to do all this, of course, there's got to be data, private information provided to resolve these points. Is the child younger than 14 or 15 or 16? And is the parent really the parent, or is the guardian really the guardian? So actually, the act is going to include require the exposure of personal information if it's going to work the way the legislature has chosen to do it. Well, then the SMP must permanently delete all personal information held by it for a terminated account, unless legally required. Well, how does that be done? In reality, if the SMP has already shared data with advertisers or other third parties, it can delete it, but the data is out there. We'll see how effective this is. Penalties, Florida can go after an SMP that committed a knowing or reckless violation of sections 2, 3, and 4 that I've summarized for you as an unfair and deceptive trade practice, $50,000 per violation. Brian, we're back to what's a violation each time or one time? Well, statute doesn't say. And punitive damages can be collected by the state of Florida if it's a consistent pattern of knowing or reckless conduct. Well, we'll see about what's consistent and what's inconsistent. Next, an account holder, that's the minor, can collect up to $10,000 in a private suit. So like Illinois, we have a private right of action here, plus attorney fees. It'll be interesting how class actions evolve in this area. And a parent or guardian can sue to collect, but it has to be on behalf of the minor. So it'll get interesting how money collected by a parent or guardian is actually used for the minor. The Act then also has a separate section that establishes a set of rules for, quote, materials harmful to minors, close quote. Now, the language used here is very much like what we see in anti-pornography laws. And here, the interesting idea of anonymous age verification becomes a defined term. Any publisher of material harmful to minors on a website or app must use either and both anonymous age verification or standard age verification. They have to offer both, use one, to verify that the person attempting to access the material is 18 years or older. And the individual is the one who decides, the person trying to use such information, whether to use anonymous or standard age verification. Well, if you're trying to trick somebody, wouldn't you use standard age? Well, we'll find out. Similar fines and private court remedies are provided in this act. And then there's a separate section defining, again, anonymous age verification. Now, this is quite interesting. It defines it as a use of a method conducted by a non-governmental, independent, third-party organized under U.S. law, but not one owned by a foreign government or by any company that is formed outside of the United States. But it doesn't say formed by a person outside the United States forming a U.S. company, which, of course, can be done generally in the United States. Interesting. We'll see if that gets tightened someday or addressed again by the legislature. The entity providing anonymous age verification is then not allowed to retain any personal information that it used to verify the age once the account is verified. And it has to keep the information that it used confidential, secure from unauthorized access. So you have to get rid of it. And then what if you come after a year later saying, well, you didn't do it right? And, well, wait a minute, I had to get rid of it. This will get very interesting. Well, this is just to say seems a well-intentioned but but somewhat misplaced effort to encourage the effort to distinguish between identity, the identity of a person, and credentials to do something. Here, to have access to a social media account. Now, other countries like Estonia use an approach that orchestrate identity. They give people credentials separate from really who they are, and that then allows them, without revealing personal information, to have access to show I really am over 14 or 18 or whatever the age is, or I have a right to vote, or I have other rights to do things without revealing personal information about themselves. This apparently is not developed enough in the United States or been accepted enough for Florida to consider using this. But this may be where it heads under this increasing use of the term anonymous age verification. Well, social media use by minors is certainly a topic of serious debate, and that includes how laws are written to deal with the addictive nature, as it can be, of social media. Legal challenges have met with opening success in several states, including one in Ohio, where a federal judge held that that state's law used, quote, breathtakingly blunt, close approach to dealing with the issue. And the judge there enjoyed enforcement temporarily for a law requiring only a one-time parental consent to let minors have accounts. NetChoice is a trade association of very large social media companies, and it's already expressed opposition to what Florida has now done on First Amendment and other grounds. And from a data privacy perspective, NetChoice advances the argument that Florida requires the sharing of personal information to verify age, and that a person is, in fact, the parent or the guardian of a minor. And wouldn't it be ironic if the impact of Florida's new law is actually to jeopardize rather than minimize data privacy of online users? We can expect court challenges. Well, Brian, Hugo, any other April 1st thoughts as we record this for release on April 4? Brian?
Nothing else from me, Joe. Thanks for having me.
Have a great April. How about you, Hugo?
Nothing else from me either. April will be an interesting month, I think, with a lot more new developments coming out of, I think, the U.S. with now the sensitive bulk data item moving through the Senate. So looking forward to report again in May of what happened.
Well, we'll see you all at the end of April to record one for May. And as always, I'll close by reminding our listeners, protecting your personal data and your personal privacy begins with you.